Okay. Okay, so today's objectives will be to introduce the background and main characteristics of copyright laws that apply to teaching and instruction. So we're going to focus on three specific things in copyright law. That's the classroom exception, Digital Millennium Copyright Act, and the TEACH Act. Then we're going to, for the different presentations that Ken and I will be giving, evaluate some scenarios where a library may advise library users on copyright laws in class and for teaching. And then finally, at the end, we'll identify some authoritative sources of information on copyright laws. All right, so with that, I'm going to switch chairs with Ken Frankel, who's going to talk about classroom exception, also known as class use. So have a seat.
Thanks. Good afternoon, everyone. Before I go into classroom exception, I wanted to talk for a moment about Section 110 of the Copyright Act. This section has 11 different points to it that deal with exceptions to the Copyright Act, especially dealing with performances and displays. And some of the scenarios which this applies in include during religious services in a house of worship, during a nonprofit agricultural or horticultural fair, also in a veterans organization or fraternal organization that's nonprofit. This is primarily dealing with things like playing music, showing videos, and that kind of thing. And then in some of the for-profit scenarios, these include playing music or showing movies in a store that sells those for promotional purposes. So in other words, a music store can play a CD in there, or a video store, if they still exist, would be able to show a DVD or Blu-ray in the store as well. Another for-profit scenario is in food services and drinking establishments. So you've been in, bars where they're playing music, showing videos on screens and that kind of thing. And there are actually detailed rules about how many screens are allowed, how many speakers are allowed according to the size of the establishment. So there are other ones as well. For example, recording books for blind or visually disabled people, or having a display of text for people who can't hear. So these are just some of the other scenarios. Now, the first and second one of this group of exceptions is the classroom use exception that I'll be talking about, and also the TEACH Act is the second one, and Christy will be talking about that one later. But what this says basically is that instructors or pupils in the course of face-to-face teaching activities in a nonprofit educational institution, such as a classroom or similar place devoted to instruction, can display those without it constituting copyright infringements. So it also mentions in this that in the case of a motion picture or other audiovisual work, that the performance or the display of the individual images is given by means of a copy that was not lawfully made under this title, and that the person responsible for the performance knew or had reason to believe was not lawfully made. So what this means is that bootleg copies are not allowed, only the original work. So in order to qualify for this exemption, just to go over that again, the key points: you must be in a classroom or similar place devoted to instruction. And Kenny Cruz does mention in his book that In certain instances, a library could be considered a classroom or place devoted to instruction,
Yeah.
such as our instructional lab. That you are there in person, engaged in face-to-face teaching activities, and that you're at a nonprofit educational institution. So if all of those things are in effect, the copyright exception the classroom exception can be used for the following purposes, that instructors and students both alike can read text, recite poetry, perform scenes from a play, sing songs. They can play recorded music or video from legitimate copies, and this can include an entire film. They can show art slides or original artworks, and project websites onto a screen. So all of these things can be done without seeking permission, paying fees, or conducting a fair use analysis. When is the classroom exception not applicable? So, of course, outside of face-to-face classroom teaching environments. And these can include things like distance learning, whether it is synchronous or asynchronous, because it is not face-to-face instruction. Also, online teaching settings, such as posting things in an LMS or a course website, are not allowed. And the reason for that is that this exception does not include making copies or distributing them in class. And of course, also, this is not applicable at for-profit educational institutions. So we have a few scenarios for the classroom exception. And I will read these, and then we can get feedback from the attendees on your opinion as far as what you think about these. So the first one is Ms. Perez's high school drama class has been performing scenes from the 1984 play Glengarry Glen Ross in the classroom. She decides to have a performance of the play in the school auditorium and charge admission as a fundraiser for the drama program. So weigh in as far as whether you think that the classroom exception would apply in this case, and why or why not. And you can either unmic and give your opinion, or you can type it into the chat as well. Your choice. And Christy is monitoring the chat, and will let us know what people are saying.
Okay, so Lori and Tiffany say they can do that. And Lori adds that in order to charge for the performance, they would have to pay for the rights to perform and charge. So like if they're charging admission, that's different. Leah says no, it would not apply because Mrs. Perez is charging the fee. And then Pam asks if she even has permission to perform the work. And Brian says no, performance for work. So no can do seems to be the collective wisdom of the chat people.
So it's sort of a trick question, because the reason that classroom exception does not apply is that it is not in a classroom, it's in an auditorium. So that is the primary point that I wanted to make here. But also, as far as the charging, in certain instances, this can be applicable if the profits from the fundraising are used to support the educational program. But that's not something we're going into today. The main point is that it's being displayed in an auditorium and not a classroom.
So in a way, this is an issue of performance rights more than copyright. That she's going to have them do a play and everything, and instead of doing it for instructional purposes.
Yes.
Okay. All right. Did anybody want to add on that scenario of the drama class and the play? Oh, Tom says, what if the auditorium is the classroom? Ooh, well, auditorium, I think, is more for performance, and classroom is more like a learning setting. What do you think about that, Ken?
I think if the class was regularly scheduled and held in the auditorium, that would be fine. But in this case, it's bringing in people from outside of the class itself. So I think classroom exception would not be applicable if other people from outside of the class were attending the session.
Yeah, Tiffany adds that, what if the auditorium is the classroom?
Yeah, and once again, if it was just being done with the class members, I think it would be fine. But if it was bringing in people from outside of the class, and like parents and other people, that it would probably not be applicable as far as classroom exception. Now, classroom exception is not the only way to not have copyright infringement, but that's the one that we're talking about first today. So we're thinking of these scenarios in context of that subsection 1 of section 110. So,
and this particular scenario really shows how important the details matter. Like, for instance, because this is going to be a play for the school auditorium and admission, that's really going to change what Mrs. Perez can and cannot do with Glengarry Glen Ross. So always mind the details in a copyright question.
Yes, so for that one, I put in a few other issues to kind of make it a little more tricky. So scenario number 2, due to COVID-19, Dr. Musashi's class at the for-profit Hudson Technical School is being taught in hybrid format, where some students are present in the classroom and some are participating online. He wants to show an authorized DVD in class. Does the classroom exception apply in this case?
Ooh, I think we've been asked this question once or twice now in some shape or form.
So once again, you can weigh in through the chat or by unmiking.
Okay.
Unmuting.
Okay, so Deepa asked if he got authorization. Leah's not so sure because everybody would need to be present and in person. And then Lori added that since Dr. Musashi's class is at a for-profit school, the classroom exception probably would not or would never apply to him. Yeah.
Yes, so Lori is correct. At a for-profit institution, copyright exception does not apply. And Leah is also correct that if it was a nonprofit institution, it would still not apply because not all of the people are present face-to-face in the classroom.
Yeah, Larry added that it would work for the kids in the physical class, but if he wanted to do it online, he would need streaming rights. And maybe if the library or the resource center had a link to the, or a subscription to that particular movie in a movie database. So there's another way.
Yes, that's right.
But not necessarily the classroom exception.
Were there any other comments?
And Pam noted that he was in a for-profit institution, so
yes.
This would not apply, and because it's not all in person. I like this scenario, and thanks for having one like this, Ken, because this actually touches upon the Digital Millennium Copyright Act, where in a way we can probably re-ask this question, thinking about the DMCA and see whether or not that would apply. So I'm going to yank that one, Ken, if that's okay.
Absolutely.
Okay.
You can recycle it.
Sure.
Okay, next scenario. Mr. Van Driesen's high school social studies class has a very stressful exam coming up, and he wants to play some relaxing new age music while they take it. he has a Yanni CD that his colleague, Mr. Buzzcut, burned for him.
So bonus,
Does this, in this instance, does classroom exception apply?
bonus to whoever can identify the TV show where these two characters appeared. And I'll give somebody a copy for the place or the location.
So let's see what people are saying about this one.
Okay. Oh, I think Tom recognized him. Lori says that Mr. Buzzcut did a naughty thing by burning the CD. Yes, he did. Yeah, it's not a legal copy, as Pam had said.
Yes, so they are correct. Because this is not an authorized original copy of the Yanni CD, Mr. Van Driesen would be not in compliance with the classroom exception. Now, if Mr. Buzzcut had loaned him an original copy of the Yanni CD, he could play that one. So that is the key point there.
Nobody's going to try to guess what TV show this was from. Ah!
Did someone get it?
Lori said that she had to look it up, and Tiffany correctly said Beavis. So yes, this was from Beavis and Butthead. They said they both had to look this up. Influential comic from the 1990s showed on MTV. So Mr. Buzzcut and Mr. Van Driesen were teachers at Highland High, where these never-do-well characters, Beavis and Butthead, went to school.
Yes, and I don't think Mr. Buzzcut would actually own a Yanni CD.
Well, maybe he got it for his stress relief.
He was very intense, and there were veins popping in his in his forehead.
True.
Next scenario, Professor Williams has an authorized DVD of Star Wars that she wants to show selected scenes from in class. She decides to save these clips onto a flash drive and to show them in class rather than use the DVD player. So does the classroom exception apply in this case?
Oh my, this one's a little more challenging. So it's her copy, and she's making her authorized legal copy, and she wants to make a copy from her own copy.
Yes.
Okay. A couple people say yes because it's in person. Let's see. Yeah, a couple people are saying that Lori and Leah seem to agree that no, because she saved it on a flash drive. But one person does say yes because she owns the authorized copy. Maybe it's for, and since it's for her own use, maybe.
Well, this is another tricky question, because if she had actually shown the scenes from the DVD itself in the classroom, it would be fine. However, she has copied the scenes onto a flash drive. So in this case, the classroom exception would not apply. So I guess that concludes this section on the classroom exception. Now, classroom exception is not the only way that instructors can avoid copyright infringement. There are other ways to do that. And so Christy will be up next to discuss some of those.
If you want, you can use this.
Okay.
I sterilized it.
Thank you.
Okay, well, this is an interesting lesson in how to cope with technical issues. Ken and I are playing musical chairs. Thanks for your participation to the classroom exception there. And then we can go back to the beginning of the recording later on and take note of what Ken had included, that also in terms of rules about copyright, right? Like public performances and things like that. I think that's almost like another topic that could be discussed too. Yeah. All right, so next we'll be going in the Digital Millennium Copyright Act, known as DMCA for short. Now, the Digital Millennium Copyright Act has a much different tone than all the other copyright exceptions that we've been exposed to. So just to give you a brief background of how it came about, now copyright law had previously talked about very broad applications of copyright law that can be like tailored for different situations, but because of the internet, things kind of got a little weird. It began in the 1990s because of the increased use of internet and the use of digital technologies. Basically, a lot of the copyright holders and various intellectual property wanted to know and maintain their copyrights when things could be reproduced so quickly on the internet. Congress, educators, librarians, and the public were involved in these discussions. Then in the mid-1990s, the World Intellectual Property Organization had a 1996 copyright treaty that aimed to protect the copyrights of digital environments. The United States signed this treaty, and when they signed it, they agreed to have its provisions into its own laws. So then in 1998, it was passed in the US. And not only did it address digital issues of copyright, but also online commercial activity, which I'll also touch upon. It was finally enacted in 2002, so it took a little while for it to work its way into the book, so to speak. DMCA discussions did influence later law in the Teach Act, which also occurred in 2002. The DMCA also changed some of the language in the copyright law, section 108, that has to do with the library exception when it comes to copying materials. DMCA does allow some limited preservation and copying of materials into a new format, especially when its original format is obsolete or just not available. So maybe, for instance, for works available only on the Betamax, that can possibly be put in a digital format because nobody really has the Betamax technology anymore. So the goals really were to protect the intellectual property rights of creators and copyright holders. So like I said, it does have a much different approach to copyright than the classroom exception and the other exceptions in copyright law. And then it also wants to promote online commercial growth. So eBay, Amazon, I forgot the car service where you can actually buy a car online, but commercial online activities like that are things that this law also wanted to encourage. So in comparison, the DMCA is a lot more prescriptive and specific and not quite as open to interpretation as the previous copyright exceptions that we've looked at so far. Okay, so I'm going to look at three key concepts of DMCA. First, we'll go into the prohibitions. DMCA specifically says there's certain things you cannot do with copyrighted goods in an online setting. And they talk about this in their anti-circumvention law, trafficking of circumvention technology. And then they also describe some legal and criminal penalties for doing that. I'll talk about those in a moment. Then you've got some exceptions. So here DMCA says you can't do this, 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 this. But then in the exemptions, it says, well, you kind of can, and I'll describe what that means, because at first you're thinking, wow, that's a lot of things you can't do. But then it says, but there are a couple things we will allow you to do. And then another key concept of DMCA, it doesn't really apply to us so much, but it's good to know because it is part of the law, is a liability of online internet service providers and providing them a safe haven, because they were open to, they didn't really have as much legal protection when the internet first came out. Okay, so the key concepts of DMCA are the prohibitions. Anti-circumvention is something they discuss. It does not allow tampering with the locks or other types of technology that secures that secures content. So whether it's a password to a Microsoft Office Suite CD, DMCA says you cannot hack the code so that you can make copies and give it to your friends. It would also apply to DVDs that are copyright, they have copyright protection. And the law addresses access control specifically. So really DMCA says it's illegal to tamper with the technology that gives a person the resource or the work or something that's protected by copyright. DMCA also prohibits the trafficking of circumvention technology. So in other words, if I'm going to tease Ken again a little, let's just say Ken and I put our heads together and we had this really good idea for a DVD lock breaker that we can make money, you know, he can supplement his pension, I could get myself a new car finally. That's illegal. So Ken and I shouldn't do that. We should come up with better ideas. So DMCA basically says that's not allowed. You can't sell it, you can't distribute it, you really can't make it. So just to give you some examples of some of the prohibitions, I had mentioned hacking the encryption code for computer software package to make copies and other similar technologies. And this could also apply to websites. This could also apply to our databases. Sci-Hub is another example of someone who is violating the DMCA. Sci-Hub, in case you didn't know, is a site that gives access to subscription available materials, and they're often protected by a paywall or other access control. Some computer scientist in one of the former Soviet republics had generated some code. So if somebody pulls in a title or certain identified information about a work and goes to SciFinder, it will generate a code to give people access to Elsevier, Wiley, and these other technologies. So that is a violation of the DMCA. The DMCA also outlines some legal penalties focusing on commercial or private gain. The first offense would be a $500,000 fine or 5 years in prison. And the second or more offense would be up to $1 million fine or 10 years in prison. And the statute of limitations on that is 5 days from the date of offense. So, gosh, if Ken and I really did come up with this idea for this lock breaking technology, they would have 5 years to come after us, but we don't want to do that. But I also want to add that nonprofit libraries and educational institutions are exempt. So it doesn't necessarily mean that we have license to disregard the DMCA. If anything, we do need to be able to understand what it is and then advise our students and even our faculty when they're tempted to do something like that. Any questions so far? Okay, so I'll continue with the Digital Millennium Copyright Act.
No questions in chat.
Okay. Okay, now on the flip side of DMCA, there are exemptions. Locks can be broken in specific scenarios. So you have a law that says you can't do this and you can't do that, but then it says you can if and only if. So you've got two different types of exemptions. You've got the permanent statutory exemptions that are outlined in section 1201 D through J in the copyright law. Nonprofit libraries, archives, and educational institutions can use circumvention measures to preview online materials that they're considering purchasing. So now it's pretty easy. The vendors seem to be pretty generous for the most part in giving us like a trial or complimentary access so that we can evaluate if we want to purchase a subscription or purchase the product. So, we don't really, I don't know how applicable that is. However, the DMCA also does have some permanent statutory exemptions for other types of uses like encryption research. So let's just say a computer science student is learning about encryption algorithms and other methods. They can break the locks for the research, provided they're not going to profit or write a book, I assume, but they can for their own research do that. Also, this could be done for the actions that protect minors or people under 18 years of age. And then law enforcement and intelligence agencies can also break locks and those kind of access controls for their own uses. So those are some other things that are allowed in DMCA. However, DMCA also has what they call temporary exemptions that also show how locks can be broken. It's kind of an interesting process. Basically, it works like this. It's done every 3 years, and it involves the U.S. National Copyright Office Librarian of Congress. So Carla Hayden is involved in these discussions, and then the National Telecom and Information Administration. So what they do is they take a look at the input every 3 years from the public and stakeholders. So for instance, maybe a big contingent of people say that there's certain like uses that they want to make of copyrighted digitized sources. They want to break the locks just for like fair use, for non-infringing purposes, basically. So what these 3 federal offices and agencies will do is get all this input from the public to examine different like exceptions that where the locks can be broken. So that's how that works. It's done every 3 years. And the final decisions for the next ones will be made in October 2021. And what proposals they're looking at so far have to do with the data and text mining of motion pictures. They're also examining how audiovisual works can be texted, live streamed, and preserved. So that's something they're examining and discussing right now. And then also computer programming, where jailbreaking, that is, breaking the proprietary software so it could be used with other types of items can be done, 3D printing, and then accessibility for all the works. So there are different things that they look at, and I guess it's every 3 years because technology changes so rapidly that 3 years seem to be like the de facto period of review to consider new things that come up. Yeah, so that was kind of interesting. I just found out about that recently. So the final key concept of digital millennium copyright is liability of online and internet service providers. So as I'd mentioned before, internet service providers were found liable in court cases for copyright infringement. So if one of us were to download an illegal copy of a documentary and put it on a website, it wouldn't be us that the copyright holder would go after. It would be my internet service company that they would, or the person. So the DMCA provides these protections for them. That's known as a safe, actually, that's a little different, but the DMCA gives internet service providers protections against copyright infringement. It also provides a safe harbor so that like when internet service providers will keep your cache, your history, and do things that may potentially violate copyright or other things just for the regular functioning that might. So DMCA kind of gives the internet service providers protections against being sued for something like this. And then finally, it does go into takedown notices and disputes. DMCA does outline a process for this where basically a copyright holder sends a takedown notice, but it also allows a recipient of a takedown notice to send a counter notice to say, no, this is not infringing. So it does kind of keep the conversation going about that. So I know that there's a lot of details about digital millennium copyright. There's a bit more than this, but I condensed it, trying to see what would be most applicable for us in a library setting. But DMCA does give some limited rights for us to use DVDs and copyrighted, and like copyrighted materials in online settings. A couple of the scenarios that Ken had presented would definitely be an application of the Digital Millennium Copyright Act. Now, one thing about DMCA is that it has a lot of conditions and prohibitions that need to be carefully followed. Ken Cruz this actually came out of his book. He definitely recommends that a person is very confident with DMCA before they want to apply it. And then where the library steps in is we can tell instructors about this so they can decide on their own risk levels. We don't say yes or no to their questions per se, but we can say, well, this is what DMCA says. This is what, in layman's terms, what it says. So the professor or instructor can decide on the use on their own. And something else I wanted to mention too, this came up in previous copyright education courses that were in the library over the years. Subscription licenses do overrule copyright law. So this applies to our streaming videos and other subscribed or e-resource content. If a professor wanted to stream an e-resource content that the libraries have, well, he or she would really want to look at how DMCA might influence that, or what their license and then the rights to the movie might dictate instead. All right. So now we'll go into a couple DMCA scenarios. I actually know about this first one from my own time at Michigan State when I was an undergraduate. A few classmates chipped in to buy an expensive software for their course. One of the classmates said she knew how to hack its lock so she can copy it and make individual copies for those who gave her money. Now, it sounds nice because everyone's broke in college, but we do need materials and resources to succeed and do the work. So on one hand, students look at it like, well, I'm saving money that I could use for my textbooks or my rent or my trip to Cancun, in April or whatever. But what would we say to the students about this particular plan? Now, we have thoughts about what we would say, but maybe how would it be understandable to a student? How can we tell a student? No, that is illegal. This is true. We can tell her that straight up. This is illegal.
Yes, Lori said it is illegal.
Mm-hmm. But what can we tell a 21-year-old college student who, they're not really thinking about the law. They're thinking about the money or making their classmates happy. What are some ways we can explain this to a 21-year-old? Oh gosh. Leah says, I hope you like prison food. Well, yes, telling them the consequences of doing such a thing would probably, it's punitive, it's negative reinforcement, but it's very factual too.
Pam says, get the university to buy a license.
Okay, good. So then we could have options, give them options to get the university to buy the license, whether it's their department or the library, maybe, or something like that.
And Tom notes that if money is the issue, it would cost more to be jailed.
Yeah, the pros and cons, the cost and benefit analysis there. Yeah.
And Lori mentions the license agreement states that the lock should not be tampered with, and that law means that you could be prosecuted.
That is true, yes. So maybe we need to introduce students to the concept of licensing because they're probably, maybe they know a little bit about it, but they probably need a little more information to take it seriously. Maybe that's a possibility. So these are good responses, but so our copyright questions won't necessarily only be to our faculty and our instructors, but we'll also be talking about this to young adults and students who have, a different mindset, different set of experiences that they're coming up with. So part of copyright consultation is being able to tailor our message and our responses to who's asking the question. So, yeah. And then a couple other questions. Let's see here. Lori adds, in terms of the license, we all just click through those licenses and we often don't can't understand them. That's definitely been a legitimate complaint that a lot of experts have been bringing up over the, especially recently. This is true, but even just to tell them licenses say what they can and can't do. And then Larry had mentioned, if we have knowledge of such an act, are we not liable if we do not report it? I'm going to take a guess. I don't think we are. I don't think we are. I don't think we are, but I might have to look at the library exception for that, because I don't think we are. I mean, we didn't do it. I don't really think the copyright law makes us police one another or anything like that, or puts a liability on a university to make sure people are compliant. But I'll put that down for my library copyright X file. What about university liability? So,
Tom notes that, as Lori said, we often don't understand the license.
yeah.
And Pam's question is, what if the student loaded the software and let the students use her laptop or library PC?
Oh, well, I'm going to guess because it was one device on one PC. Now, fair use does allow people to give each other copies of things or show each other things. So I think it would kind of be something similar to that. So I don't think it's like if somebody else doesn't own it, they can't use it ever. But this is basically you borrowing somebody's personal copy for legitimate uses and not breaking locks or anything like that. So, but yeah, fair use does allow us to use work of somebody else, in limited degrees. And in terms of a library PC, oh boy, well, I guess it would depend on the policies of a library allowing things to be downloaded on their devices. Yeah. But the library wouldn't be held responsible for any not infringing uses because it's not the actor in this case. Yeah. Lori adds that sometimes a license will allow us to have a copy of software on multiple devices. So she's referring to Microsoft 365, which FAU lets us have. We can have it on up to 5 devices. So yeah, sometimes the licenses might allow some privileges or uses that we didn't think it would. So I didn't know about that personally until Lori had told the instruction engagement department. So, yeah. So yeah, this covers a lot of different areas. All right, so we'll go to number 2. An instructor wants to use clips from Black Swan and Swan Lake for comparisons in a hybrid choreography class. So his class is both in person and on Canvas. So what are some questions we should ask him that would influence our advice? So we are kind of looking at this a little backwards. What are some things we should ask him when he wants to know about legally using these 2 CDs? What are some details we might want from him? Okay, so.
Lori says, are you referring your students to URLs for clips that you created in academic video online?
Okay, so one possible question we could ask is whether or not he's aware that we might have this online, maybe. So maybe he's not aware the library may have copies of these that he could use. Now, think also about previous copyright topics we've covered too. Think about the other exceptions that might be allowed. What are some questions we might ask? Because in a way, fair use can kind of apply here too. Yep, so Gabby says, what about the length of the clips? And then Lori was talking more about the academic video online, also known as AVON. She says it allows you to create clips and will assign URLs for them. So maybe talk about some of the features of the videos, the streaming video services that we have. Yeah, that will help him reach his goal. Larry says he could see if Dawn could get the movies to stream this to allow the hybrid kids to to log in remotely and not go into the class if they, are still afraid of COVID. Yeah, that's another possibility. I might ask about the heart of the work. You know, what scene does he want to play? Like, is he doing like the most important scene of the whole work? Maybe, which might weigh against fair use, is a possibility.
Now, Lori mentions that only links to clips should be used as it is a hybrid class and the videos should not be shown in the hybrid class to the online students.
So, yeah, we can ask him, is he going to show this video live or asynchronously? We could recommend that he provide the clips, you know, to the students who can't be there in person, because the people who are not there really can't be shown like a streaming that he's doing in his own classroom, and then it's being transmitted to others. Yeah. I know it's a lot of sticky details, but these are the kinds of details that we'll be confronting when we have these kinds of questions. And then also for those of us who field a lot of questions from the public, sometimes we have to tease out more details of their use. Maybe we'll find some specific that changes the whole game. Maybe someone is saying, hey, this is my beading club and we're meeting on Zoom and I want to stream a movie with this apply, you know, or versus someone who's doing like a material art class. Well, that's going to be different, you know, in a public institution. You know, the things will be totally different for, say, someone in a hobby club versus somebody in a public university or college wants to show something online. And Lori asked if the link to the Kenny Cruz's book is available. I am happy to say it is. At the end of the PowerPoint, which you all got in the email, in the work cited is his work and a link to the ProQuest ebook, sent that where it appears. So we all have it. It's an easy access for all of us. So, all right, but thank you. Thanks for your insights on this and the kinds of questions. Sometimes the e-resources kind of skip over me, so thank you for filling that in for me. Okay, so finally, I'm going to introduce the TEACH Act. Now, FAU does not qualify for the TEACH Act, but I wanted to give you some information about it so that you know what it is and where it fits in the broader scheme of copyright and education and instructional purposes. The TEACH Act stands for the Technology, Education, and Copyright Harmonization Act, which was passed in 2002. Harmonization basically means when different places have their laws kind of like start at a baseline. Like the reason why our copyright is 70 years is because of a treaty we're in, an international treaty that we're in that recommends the minimum copyright term is 50 years. So harmonization basically means, you know, different places will have at least a baseline of commonality in their laws, legal stuff. So Kenny Cruz described this as an update or supplement to copyright law due to digital sources and online education, but it's not necessarily a substitute for the usual exceptions. So perhaps fair use can still come into play, even though it's a digital environment. Maybe a library exception, course reserves or interlibrary loan could be considered too. So you got other options remaining. Now, the TEACH Act has not really been adopted as widely because it has a lot of requirements, and we'll go into those in a moment. A lot of institutions find that the provisions are very complicated, costly, or they just can't do it. You know, they just don't have enough people or resources to get it done. But like I said, the reason why this is brought up is we may be in situations where we advise those at FAU who may need an alternative. So somebody may say, well, hey, I was able to use my TEACH Act at UF. I don't really know if UF allows TEACH Act there, but in case they did, well, here's, you know, we can understand what they were allowed to do and then advise them what they can, you know, possibly do here. And then plus we've been getting a lot of interesting questions in Ask a Librarian, right, guys? A lot of interesting copyright questions lately.
International.
And even a couple international copyright questions too. We had somebody from Italy and someone from France want to use items from the digital libraries and the Palm Library collection, some pamphlets, and they wanted some copyright permissions to do that. So we had to advise them and direct their request elsewhere. Yeah. Okay, so the TEACH Act allows the transmission of copyrighted works as a part of a course at an accredited nonprofit educational institution when certain conditions are met. And those are going to include the following. So like the Digital Millennium Copyright Act, it is quite prescriptive about what you can do and kind of what you can't do too. So you can use a range of materials and works in online or distance learning environments without the need to get permission or pay royalties. You can use limited and reasonable portions of a work, or if it's comparable to what will already be done face-to-face. It can be done for live or asynchronous courses or sessions. And then another nice benefit, those who can do the TEACH Act, is that it gives these institutions the ability to store, copy, or digitize materials, and even like their teaching content that uses this copyrighted material too. And then kind of similar to the Digital Millennium Copyright Act in terms of obsolete or outdated technology, TEACH Act says that an analog work can be digitized if a digital version is available to the institution, or if it is locked to prevent uses for the TEACH Act. So the TEACH Act does kind of give you one of those lock breaking exceptions that you could do here. So, all right, well, thanks Pam for coming in. She's got a meeting, and we'll have this recording out probably by the end of today or tomorrow on the page. I'll let everybody know when that's out. So we know about that copyright law and exceptions are typically pretty generous to nonprofit institutions, but a person cannot use a TEACH Act without the following in place at their institution. Oh, thank you, Michelle Kiva. So she's heading out as well. Okay, so the type of institution, nonprofit, and its policies. But I think the most prohibitive part of the TEACH Act are the technology protections that they have in place, and then the instructional planning. And as I'd mentioned, FAU does not currently comply with these and cannot use a TEACH Act. And it's not unusual. A lot of universities do not and cannot use the TEACH Act. So we'd mentioned the type of institution, accredited nonprofit educational institution. TEACH Act requires that they have a publicized copyright policy for students in terms of the copyright for course content and a notice of copyright for online materials. And then it also requires copyright educational materials, and that they're updated and that they describe copyright laws and promote their compliance. The second one has to do with technical protections, and that is that access is limited only to enrolled students, and that reasonable technical controls are in place. And this would keep people from keeping it for past the time of classes is in session or for the semester, and that they cannot further distribute it. So it's not just password protection, that's not enough. They want people, they want institutions to have measures in place that keep a student from downloading it or copying it or sharing it. No kidding. Disabling copy as well. So it's that's where a lot of places feel they can't really comply. I know that here at FAU, and this is something you might want to note for your if you're ever asked about Canvas, Canvas has very limited ability to do this. It does have a password protection, that's good. It allows students who are only in the class and whoever the instructor or professor permits to be in there, that's good too. But it cannot prevent downloading of documents or saving a document. Although PDFs or things that they might embed can expire at a certain date, I guess a lot of places feel that's not enough to keep it from being distributed further. And then finally, you've got some instruction requirements. So permitted works for the TEACH Act have to do with the performance of non-dramatic literary or musical works. And they do say reasonable and limited portions of other work is all right. And then works displayed are comparable to those what would be done in a live session. An instructor must be the person who does this, so a student would not be allowed to do it on his or her own unless an instructor or a professor was supervising them. And then also they want that the work is used as part of instructional activities and of material assistance. So if a person feels that it's really important for teaching the content or the course or for the student understanding, that's going to be a big deal. It could be done live or asynchronously. And then, of course, if the transmission is limited to the students to the extent that it's technically feasible. So Teach Act does not apply to a few things like scanning and uploading works for unlimited or access or use. Teach Act does not apply to textbooks and attached digital content. So it's like Pearson and McGraw-Hill sell you these books, but then they also have a CD or like an access code for people to get additional online things. So those materials could not be used in a Teach Act. MOOCs, multi-online, I forget the acronym, massive online open courses, I think it is. Those that are in the online course marketplace that were created for instruction, transmitted through digital works. So I guess if I were to use something like Coursera, something from Coursera, and use it in a class, Teach Act would not apply to that, I guess. And course packs, Teach Act does not apply to course packs or outside or supplemental readings, e-reserves, and interlibrary loan. And then it says converting analog materials to digital formats, except with permission, and if the digital version is unavailable. So there. And then, of course, library e-resources with licensing agreements is where the Teach Act does not apply. So once again, licenses always overrule the law. All right, so I see that Dawn Frood had shared the link to Kenny Cruz's ebook in the chat. So for those of you who want to see it soon, you got that available to you. All right, so I've got a couple scenarios here. Okay. Professor Pearl is new to FAU and her previous employer had a Teach Act policy. She wants to stream a clip from her personal copy of a DVD during a live session of her class held on Canvas. So this would be a synchronous, everybody at the same time and live. The professor got to do this without issue at her previous institution and was surprised when she was advised not to do this. She came to you for help because the students understood the concept much better than after watching the DVD clip. And she really wanted to show it. So what would you recommend to Professor Pearl? So you think about the details at hand here, what kind of class it is, what material she'll be using. What else we got? So we're not necessarily applying the Teach Act here, but what are things we can tell Professor Pearl? Okay, so Lori says, check with the liaison, the librarian liaison, to see if we have the DVD available on streaming. So this could be used for live viewing in a synchronous online class. Yeah, that's definitely the safest way to go, or the lowest risk way to go. Do we have any fair use advocates here?
Larry says, well, we do not have the Teach Act in place, so under those guidelines do not apply. But I would recommend to see if she could see if it was offered or available via YouTube or streaming rights via a database.
Okay, so.
And YouTube would be fair use.
Okay. She would need to do probably a little analysis a fair use analysis looking at the 4 factors, if it would qualify as fair use. But what about what she finds on fair use on YouTube, though? That's the other question.
Lori asks, would she also need to verify who had posted the DVD to YouTube?
Right, that's a possibility. That if she uses a YouTube, that she's not using a bootlegged copy of it or a clip.
There's lots of them on there.
Yeah, there is. Yeah. So I kind of think she might be able, I mean, if she does a fair use analysis and she's not using a significant portion of the work or the heart of the work, and it's limited to this class, I almost think that she might be able to go with fair use. And she's here, so it's a nonprofit educational institution. And
Tiffany asks, could she reach out to the production company for written permission?
Oh, yes, that's an option that she could make too. She could request the copyright holder for that. Okay, Larry says if it's on YouTube, she can tell the students to go where to find it. So, and then, oops, sorry, I was just trying to get the chat and it bounced me.
Tom asks, what if she made it an outside homework assignment and provided a YouTube link? Maury says, also Vimeo has bootlegged copies, but I don't think of them often when looking for complete copies of movies, but I've found some BBC videos on Vimeo.
Yeah. Well, it looks like you know, some people are leading to YouTube. I'm personally leaning to fair use. My only concern with YouTube is using a bootleg copy, but then again, that's kind of a low risk activity for Professor Pearl, because one thing is, if somebody puts an unauthorized copy on YouTube and somebody else views it, well, they call that a downstream user. They cannot be sued or prosecuted for copyright infringement. It's really ultimately whoever posted that clip on YouTube would be the one to get in trouble. I mean, she can get away with it, but I know that some people who approach copyright more conservatively might say she should do something differently, but that would constitute a fair argument too. And then Lori asked if it would make a difference if she made a recording of her live class that showed the video clip. Would that be a consideration? Well, I know that Digital Millennium Copyright Act does allow some limited use of that, very limited use of recording, a very limited amount. So I think she could probably, she'd be able to do that, as long as she's not showing the whole movie and recording it. So yeah, I think what Lori said, you know, yeah, I think the amount would probably, you know, a fair use analysis would help guide that question. Yeah. So I know, aren't these fun? And yes, these are the kinds of questions we will probably be asked. So. All right, and here's another fun one. I did this again in the spirit of the recent Ask a Librarian questions. Marcus, an FAU alumni, is an 8th grade English teacher in a local school district that has policies in place for the TEACH Act. His school temporarily shifted to online learning on Canvas due to the highly contagious Labrador flu. To help with engagement in this literature unit, he'd like to have the class do a group reading of Shakespeare's Romeo and Juliet, where students read or voice act excerpts. I'm assuming they all have the book or a public domain copy of the book they found somewhere. He used the Ask a Librarian service so he can be sure he's following copyright in the TEACH Act. What would you recommend? So based on what we've heard about TEACH Act so far, and based on what Marcus is doing, I'll add he had such good service at the library that he came back and wanted to answer our question. Wanted us to help him. So Larry asks, are they only reading it as part of the class? So yes, it's just his English class that's held on Canvas. Lori says that Teach Act requires that non-dramatic works can be used. Okay. So Larry says if there's students reading, then okay. Yeah, so I'm just taking a look here at what they allow you to do. Yeah. Non-dramatic literary. So they're opening so they're not looking at the actual play script, for like a scripted play, they're actually reading the book by William Shakespeare. So, yeah. But that's I know, but that does kind of come up. So Romeo and Juliet being dramatic, wouldn't this be prohibited by the Teach Act? Yeah, because it is a play. Yeah, I think we might have to tell Marcus that, we might have to tell Marcus that, well, because it's a play, he may not, but then, when was Shakespeare published? Okay, ballpark figure.
Hundreds of years ago.
Hundreds of years ago. A long time ago.
So that would be
1600s.
in the public domain, wouldn't it?
So he can, because it's public domain work. So it doesn't, and a public domain work does not have copyright protection. Tiffany gives us an example. Thank you. The exact date. Thank you. 1597. So wow. There we go. So definitely in the public domain. So, okay. So yeah, I think even a subtle detail like when something was written or published would come in handy there. Yeah. And then Lori suggests or thinks out loud, so we have to keep going back to if an item is under copyright before we even think of these laws. Ooh, good. Yes. Yes. That's probably one of the first things to do, is to look at the copyright. Yeah. I mean, the question's really focused on applying the particular law or exception, but whether or not something has copyright protection will still be an issue. All right, so Lori says the students are reading from a copy that was copyrighted by a publisher recently. Would this still be okay to use? That's a good question. Probably not, because the law says non-performance. I'm sure there might be a Romeo and Juliet copy on Project Gutenberg, maybe, or the University of Pennsylvania e-texts of works in the public domain. That's a way we can kind of steer around that issue. If they're reading from a copy that's under copyright. Yeah. Then Larry brings in that since they're reading it as part of the class and they're not performing it as a production, well, that kind of goes in with the classroom exception. But since it's a dramatic work, I think that's the big fly in the ointment here. And Lori says we need a copyright lawyer. Yeah. So, and then Tiffany wants to know if they'll be doing the whole play, the meet the play, or just selections. Well, that's a good point she brings up, because if they're only doing sections or little parts, that could possibly constitute fair use. That's a possibility. All right, well, thank you for your participation in that. Did everybody have any final questions or thoughts they wanted to share? You can turn the mic on if you'd like, or put that in chat. I also wanted to give a notice for our next master class. It's going to be a week from today, April 27, from 1 to 2:30 p.m. The title is Copyright Matters, Images, Tables, Plagiarism, and Infringement. So we're going to talk about copyright, Lori and I, and how it applies to those particular areas. Since there's going to be a group activity in that, please pre-register. I sent an email link to everyone. So if you could just pre-register, a link will be sent to your email, and then you can go into the Zoom meeting. So I'm going to try to experiment with the group activity in Zoom. So this ought to be interesting. So all right, so there is some additional information you can look at on our LibGuides. We've got one for classroom exception in DMCA, and then the Scholarly Communication Toolkit has a section on copyright that pays attention to copyright in library settings. And then the works cited, so there's the link to the Kenny Cruz book that's available to you all. But Ken and I would like to thank you for, yeah. There's Ken. So thank you all for coming today to the Copyright and Teaching presentation, and we'll see you next week. And thanks again to everybody. Thank you for your questions, your comments, your ideas, and getting your hands a little wet with copyright. All right, bye everybody.
All right.